Super. So, first of all, you're all very welcome. My name is Mary Donnelly, and it's my very great pleasure to kick things off this morning. Some of you, you're very welcome back. You might have been here with us yesterday evening, where we had, I think, a really, at least I thought, excellent session. Today we're digging deeper. So last night we sort of set a broad scene. Today we're digging deeper. So quite a practical day today is what we hope. But before we talk about any of that, happy International Day for People with Disabilities. What a lovely day to be thinking about the Assisted Decision-Making Capacity Act and how we can ensure that it operates better to serve the people for whom it is intended and who we hope can benefit from the Act. I'd like to welcome you all in the room, either welcome for the first time or welcome back. I'd like to welcome everyone who's joining us online. We have over 700 people registered to attend the live stream of the conference. And down there in the corner, we have some excellent people who we've worked with before who are making sure that that streaming is working, and we hope very much it is. I know it's never as much fun to join online than to be here in person. But we will do our best to include you as much as we can. The Q&A function on Zoom is open, so please put in your questions for panelists, and we will try to integrate them as best we can during the question and answer sessions. For those in the room, please note your nearest fire exit. Anya last night did a lovely version of this, which I just feel I'm not going to do so well, so they're here and here. Or there and there is probably more accurate. There is no fire drill planned, so if you hear a fire alarm, please evacuate the building reasonably calmly. A couple of points on CPD. We've been awarded 5 CPD points from the RCPI and the NMBI for the conference today. If you wish to receive a certificate of attendance, please let Shem or Sandra know when they're out at the reception desk if you haven't ticked the box already. Attendees who are members of CORU, the Law Society or the Dental Council of Ireland can use their certificate as proof of attendance for your own CPD records. And again, if you haven't alerted Sandra or Shem about the fact that you need a certificate, please make sure you do so. We're expecting a full house, so try if you can not to leave any empty seats. But we're not at full house level yet, but it is a bit early in the morning. So without further ado, one final point, we have a packed schedule. And one of the things we've really tried to do is to get as many people from as many different perspectives as possible. So we will be keeping to time, which makes me nervous that I now have probably overrun my own time. So welcome. I hope you have a very good day. Please do engage with the questions and answers. We want this to be as interactive as possible. And I now have the pleasure of handing over to Anya Flynn, the Director of the Decision Support Service.
Thank you very much, Mary. I think that was immaculate timekeeping, such that I might borrow 2 minutes from you. Welcome, everybody. Welcome to those attending online. So I'm tasked with giving an update from the Decision Support Service in respect of our own delivery of our statutory functions, which of course does not represent the totality of the Act. The DSS and the Act are two different things. We're established under the Act. We deliver functions under it, and more of that as I go along. But sometimes they're spoken of almost interchangeably, the DSS and the 2015 Act. So the Assisted Decision-Making Capacity Act, and I know this is a well-informed audience, was enacted right at the end of 2015 to reform the law relating to persons who require or may require assistance exercising their decision-making capacity, whether immediately or in the future. So I think the word immediately there references the new support framework for people who need to access it, and it's important to identify what needing to access the new support framework really means, and I think that's something that we'll cover in the next session. And the in the future piece refers to the important tools for advanced planning contained in the legislation. At its time of enactment, right at the end of 2015, it was welcomed by Inclusion Ireland, with whom we still have regular engagement, as a seismic cultural shift towards a rights-based approach of choice, control and consent. Then, just to keep things exciting, before it actually commenced in April of last year, the Act was amended by way of the 2022 amending legislation. Then the Act, as amended, finally came to life just over, what are we now, over 19 months ago, in April of last year, which is when the Decision Support Service, having been in project mode up to that point, began delivery of its statutory functions. And these are, in summary, some, not actually all, but the principal statutory functions which are conferred on the Director of the Decision Support Service, me for present purposes, under the Act. And the Director is appointed by the Mental Health Commission to carry out those functions. So I've been in post now since 2017, a large component of that time taken up with setting up the Decision Support Service, very well supported by Mental Health Commission colleagues and the growing DSS team, and I'll introduce you to some of them in a moment. Our funding and overall responsibility for the Act is with the Department of Children, Equality, Disability, Integration and Youth, which I have learned to say at speed, as I said last night, and which will probably shortly be called something else, I'm not sure. But they have taken over from the Department of Justice and Equality, as it then was, since 2020, since the formation of the last government. Our functions I generally summarise as being to promote and to inform, to be a source of information. And it is so important that good information is out there, reliable, accurate information is out there. And we do aim to be the source of truth around the Act. I think we're specifically tasked with that. To provide information and guidance to those who require it, both people who wish to avail of the supports under the Act and all those who interact with them, including in the role of formal decision supporter. And also to recommend organisational change. As I'll be saying, we have a lot of engagement cross-sectorally because this is an Act which impacts for so many professionals, services, individuals and their families. So we do have that function also to try and be, and it's a challenge, to be a vehicle for managing that change of hearts and minds, which means that the Act can properly deliver. We maintain and supervise we maintain registers and supervise arrangements which are put in place under the Act, investigate complaints about decision support arrangements, not about anybody else. We have certain panels, and I'll mention those as I pass along. We have published codes of practice. They were written together with other expert working groups and have been published since before commencement last year, together with various supporting materials. We have quite lately acceded to the function of central authority under the Hague Convention, and overall a duty to report back to bring the necessity for change to the Act to the attention of government. And we are bound by the guiding principles, which we'll be thinking about more deeply, I know, in the next session. And those are some of the guiding principles I've highlighted, as we always do, giving effect to past and present will and preferences, very much informed by the language of UN CRPD. And the protocol came into effect just at the weekend, as we spoke about yesterday. There's no reference in this legislation to a best interests approach. That I don't expect you to interrogate, but that was the pathway to establishment of the DSS. I think we had 30 active projects across 6 work streams to bring it to fruition. So that finally culminated in commencement last year. Our work isn't entirely done in respect of some of our digital functionality. We're still closing out some parts of the back office parts of the system. And that is how we do what we do. So the DSS is divided into 5 broad functions, and I'm joined by the heads of most of the functions today. So we have Joanna Macklin, who heads up our DSS panels of DMRs, also special visitors and general visitors. Aoife McMahon, they are in the room, who's head of registration, Kate Frowan from supervision, complaints and investigations, and that's Patsy Fitzsimons. And in the interest of an audit gender balance, we have Ian Grehan, who's head of operations, which includes our information services function. I think the 3 tiers of support will be familiar to many of you. So we have the decision-making assistant working up to the co-decision maker, and then the decision-making representative appointed by the court. So in this presentation, I think it's the purpose to show how we interact with those different tiers of supports, and perhaps just to point to some emerging themes, and give you an idea also of our statistical updates, as I know everyone likes to hear how we're getting on in terms of actual numbers. The decisions that may be supported, again, a nod to the next session, what we're saying here is that whilst these, and I won't enumerate them, are the sorts of things which are capable of being incorporated in any of these decision support arrangements, the fact that somebody who may be termed a relevant person has a decision falling under these headings to make does not mean that the starting point is to think about, well, then how do we slot them into the new support framework? That's not, I repeat, not the starting point, but again, more of that in a moment at the next session. Section 138 is a bit of unknown territory, really, because it's not actually clear what that section is saying, but how we interpret it is that it's saying that here is a list of things, a finite and exhaustive list of matters in respect of which you cannot have somebody decide with you or for you because the existing law, the pre-existing law on capacity and consent is unchanged. So you see in that list the sort of intimate, personal or status-changing decisions that are out of scope, including a decision to marry, a decision to divorce, consent to sexual relationships are in there as well. So those aren't areas of life where you could have somebody deciding with you or for you. Sitting on a jury is in there as well. So the DMA, appointed by the person, these are voluntary arrangements when we think about the lowest tiers. As I'll be saying, we have handled a multitude of queries. I think we're upwards of 30,000 requests for information since commencement. And quite often what we get are people contacting us in entire good faith, that must be said, saying, I think I should become my person's decision-making assistant, my person's co-decision maker. So we have to say, well, what do they want? Is that going to work? Is that necessary? Remembering the principles about never having a higher tier of support than the one that you need. What a DMA does is quite practical. It's about information gathering, being that person who is authorised to gather up and explain information. That's not to say that you may not have somebody in your life who's already doing that effectively with your consent and that all of that can stay untroubled. But I suppose it's an opportunity potentially to navigate some of the data protection and privacy hurdles that might otherwise get in your way of providing that level of support, because the appointer is still making their own decision at this level. You don't need a capacity assessment. It's sent to us. There are regulations that set out how you do so, and what a DMA needs to look like is set out in our form. But it's important that people don't think you can do more than you can in the role of decision-making assistant. We have had a bit of that, where people thinking that helping to implement the decision meant implementing the decision for the person. So we have had, and these stats I believe are up to date as of yesterday, 50 DMAAs have been notified to us. They've completed that notification process. More than as many, again, almost are in the queue, having been submitted to us in satisfaction of the notification process. And if I can explain the term active application, we use that to mean that people have completed a substantive instrument and have moved to the next stage of taking up supporting documents. So there are 223 active applications in this category, and we have a bigger category, that's a subcategory of a bigger category of draft applications, which would be several times that. Co-decision making then, middle tier, deciding with a person. It is instigated in the same way. You're choosing somebody, in this case the Act is quite prescriptive about it being somebody specifically in that pre-existing relationship of trust, who's going to help you do much of the same things as at the tier below, but really importantly, they're going to take jointly with you the decisions that you have chosen to put into a co-decision making agreement. It takes effect on registration with the DSS. There's a process for doing that. And I'll be speaking about our processes in a bit more detail at a later session. There's an opportunity when I'm talking about EPAs to focus on how we do what we do and how we had to think about managing this influx of information, making sure that we do so in a secure way and also in a way that's compliant with the Act, because the Act asks quite a lot of applicants and their supporters. So there's a bit to do in making a co-decision making agreement. And if we get the chance to engage with people early rather than simply sending us a co-decision making agreement, that's time which the DSS uses profitably to say, are you sure it's what you need? Are you sure that these are decisions which you need to take jointly? Because once in, if you don't take them jointly, it's null and void. So really important, again, that people don't end up at the level above what they require. A capacity statement is required in respect of a co-decision-making agreement. Quite similarly, one is required for an EPA, and it can be submitted by a medical practitioner or a list of other healthcare professionals named in regulations, to include nurses, midwives, speech and language therapists, social workers and occupational therapists. And I've included in the appendix information and a link to training which we've developed collaboratively with the HSE for the guidance of professionals preparing those statements. The co-decision maker reports to the DSS. They're doing so out of love and loyalty, so we aim to support them. And we do carry out periodic reviews, again tasked by the Act to do this. This is not an Act which is short on safeguarding, so we have to conduct periodic reviews under Section 26, and we have been sending out our general visitors to do so. I mentioned the numbers there, broadly similar-ish, some more than at the co-decision making level, and then 168 active applications. Some of these concern quite significant decision-making. We are dealing with a pair of siblings in the west of Ireland, one of whom has received a large award of compensation. It's a medical negligence award from the High Court. She sustained an acquired brain injury. That's where the payment of compensation comes from. Undoubtedly, she would have been made a ward of court a couple of years ago, and this is instead being managed through the mechanism of a co-decision-making agreement. Some of the exiting wards, some of the people who make their way, who are the subject of an application to the Circuit Court, are deemed by the court to be suitable for a co-decision-making agreement. A bit more work tends to be involved there, because these are people who haven't particularly thought about a co-decision-making agreement or what needs to go in it, but we aim to support. I won't go too much into decision-making representation orders. I know that we have other sessions on those today, but thinking just in terms of our functions, so this is the court-appointed DMR appointed by the Circuit Court or by the Wardship Court discharging a former ward. Our panel function comes in here. We have a panel of professional DMRs interviewed. A detailed selection process has been gone through. They're vetted, they're trained. We have had now over 200 requests for nominations, which means that we have to come up with a minimum of 2, so 400 nominees have gone forward to court for appointment. We sometimes have to remunerate a professional DMR. Sometimes their payment is from the assets of the person. Sometimes we have to pay them from a scheme of fees that we are in charge of. And currently the second phase of recruitment is underway. I have heard some circulating perhaps misinformation or misunderstanding about how we deal with panel member requests. We turn those around in 5 days. There's a process for the court to communicate a request for a panel member to us. I did hear, to my surprise, I think yesterday evening, that it takes 6 or 8 weeks for us to come up with a panel nominee. No, we've never missed a KPI to respond to a panel member request from either the Circuit Court or the Wardship Court, and its days. The court order ultimately is sent to us for registration supervised. There's a reporting duty, and we did devise information on what the reporting duties of a DMR are, and that was published not too long after commencement, because we did find that in some cases DMRs, notwithstanding they'd been to court, they'd perhaps been the applicant before the court, they had sworn declarations in court about understanding their job and undertaking to carry it out. Sometimes they were actually not clear that they were going to be hearing then from the DSS and would have reporting duties. Again, our motivation is to support people being supporters. And there is an interesting section which says if you end up with a DMR, most likely a panel DMR, when the court is doing so with a heavy heart because it thinks you'd be all right with a co-decision maker, but you don't have a co-decision maker, then this section of the Act, which was introduced by way of the amending legislation, says that that DMR has to try, insofar as practicable, to carry out their decision-making with the person. We've now 630 I think active registration DMROs. Some 80 would in fact have lapsed in that the function has been carried out, or in some cases the relevant person is deceased. I'm not going to go too far into enduring powers of attorney. I include this slide by way of completeness here, but I do have a separate session on EPAs later, so all of this information will be available then. Advance healthcare directives, again, not so much the business of the DSS because they aren't registered documents. We may ultimately get regulations from the Minister for Health to have a register of AHDs, but in the terms of the Act, an AHD doesn't require registration to be valid. So that, if we get one, I think will be more in the nature of a voluntary database. We can take complaints about a designated healthcare representative, haven't had any, and we have published a template AHD for guidance. Our searchable register, we now have 2,009 registered items. More than half of those, about 1,300 today, are enduring powers of attorney, where the person is still fine. It hasn't become an operating enduring power of attorney. So you're still relatively unlikely to encounter one of these decision supporters, but we are able to help somebody who needs to, because they're a member of a body or class of persons or have a legitimate interest to search the register. And it's a case of watching the space at the moment, because we are developing digital functionality, and a pilot project is close to conclusion with the HSE, close to being launched with the HSE as a pilot project. In the meantime, don't be stuck. If you need to know what's on the register, we are able to help people every day with that. Patsy investigates complaints, and they are complaints about decision supporters, decision support arrangements. We're a bit busier than we anticipated, because we have had 51 complaints since commencement. We thought it would take a while for these to be embedded, and by far the majority have concerned complaints about attorneys under the former Act. 90% coming to us from family members, and about 10% from professionals and services, often to say, here is somebody who, generally through no bad faith, just isn't performing, isn't paying the nursing home fees, is doing something that they're not authorised to do, and typically wearing an EPA 1996 hat. We've been able to resolve complaints informally. We find a significant majority, I would say, not to be well-founded, but the motivation is always not to have to escalate to court. We haven't been to court yet seeking the removal of any of these decision supporters, but obviously the authority needs to be there. Again, safeguarding is writ large in this Act. Hague Convention took effect on the 1st of September. As a central authority, our function will be as a facilitator for communications between the competent authorities and central authorities of other states. Not too much activity yet. We did get a call on day one from somebody in Donegal with a German court order. So that required a conversation. But because our nearest neighbours aren't in The Hague, we are, again, waiting to see quite how busy we'll be. But lots of really good preparatory work was done with our colleagues in MHC Legal. We're also contributing to an EU regulation which would see the effective adoption of The Hague, or an equivalent to The Hague Convention, throughout member states. And I'm almost done. Our communications and stakeholder engagement, we have a wealth of information and guidance on the website in various formats, which we aim to keep relevant and updated. The codes of practice are there. I mentioned the demands on our information services team. So those are the numbers of calls and emails which we've received. And since September, and I'll come to it more at the later presentation, a dedicated EPA help desk has been in place. The public information campaign, which I hope to be able to show you, was on the theme, My Decisions, My Rights, still our tagline, and that was last year into this year. And our latest public information campaign is specifically focused on advanced planning. In the meantime, stakeholder engagement continues across those diverse sectors: health and social care, banking and financial services, the judiciary, the legal profession, disability services, regulators, and really importantly, potential service users, their families and their carers. We try to do that in person as much as possible. We contribute to the interdepartmental steering group. We have bilateral problem-solving groups, I would call them, and we've set up one with banking and financial services because, as we might be hearing potentially at the next session, that's a sector where it's really important that good understanding percolates a bit better. And we have collaborative partnerships which have been really productive with Age Friendly Ireland and the Irish Hospice Foundation, promoting public awareness specifically on advanced planning. And we have a forum of experts by experience. Let me take one more minute of your time to say we don't do the following. We don't make decisions for people. We don't appoint their decision supporters directly for them. Thankfully, we don't manage money or property. We don't provide legal advice. We don't regulate professionals or other services. And we don't have direct responsibility for the delivery of training whilst collaborating on it a lot. So what is next? Increasing volume of applications, evaluation of our policy and processes. We have lots of data and we want to be able to make sure that we promote a culture of continuous improvement. We have to have an eye on our business model, our working arrangements. We're not going to be allowed to multiply like a pyramid of rabbits, I think, as we get busier. I think the department are still here. They'd be happy to hear that. That we have to manage expectations, therefore. How long is it going to take to do one of these arrangements? how can we work smarter within resourcing allocations. We were supportive of the initiatives with our colleagues in the Office of Wards of Court and the General Solicitor to promote the discharge from wardship. And overall, I've mentioned the duty to report back, and a particular report will be published by the MHC in a couple of months' time at the 2-year mark. And we also input on external policy. This is an act which doesn't amend every other piece of legislation which addresses the concept of somebody who has difficulties with their capacity. So we do often get asked to comment on other policy, other pieces of legislation, other schemes such as the Mother and Baby Home Redress Scheme, actually be good engagement with them, and perhaps opportunities for thematic reports. That's my second bell. And that's our stakeholder forum, who have helped us in development of our systems, our process design, our information and our materials. We couldn't do it without them, and they're very frank in telling us what they think about us. You'll recognise some of them. They are our decisions, were some of our decision support service champions. You probably know Fionn and Paul Alford, who I'm glad to see is giving us a thumbs up there. It doesn't always. But they are a hugely valuable source of input. That is the appendix telling you how to get hold of that capacity training. That's how to get hold of us. More from me later, but thank you very much for listening to me.
Good morning, everyone. I'm Susie Byrne. I'm Regional Manager for the National Advocacy Service and General Disability Troublemaker. It's lovely to be doing something other than watching a building go purple on International Day of People with Disabilities. And I didn't wear purple for the occasion myself either. So I'm going to sit down. I'm going to say hello to everybody at home and to everybody here and welcome you to our session this morning, which is a critical reflection on where we are so far. And we have amazing speakers joining us this morning. So I'm going to introduce each speaker. Elaine is going to keep people to time, and Jackie is going to respond at the end, and then we're going to have questions and answers. So that's what we're going to do this morning. So the first speaker I'm going to introduce is Professor Sean O'Keefe, who is the consultant geriatrician with Galway University Hospital and the HSE's clinical lead on assisted decision-making and consent. And for those of you who've been around on the ADM journey for the last number of years will well know Sean and have learned an awful lot from him. So Sean, without further ado, you're going to speak to us this morning on your reflections on the Act and where we are.
Lovely. Thanks very much. And I'm afraid of Elaine, so I'm going to start talking even without talking. It is some general comments. And I guess the first is on the level of engagement with the Act as a whole. And overall, it's been very good in many ways. I would say there's been differences across specialties. We've had really excellent input with social workers and with nursing staff, and not so much with the medical profession, unfortunately. And it's simply that the whole webinar concept doesn't actually get through to the medics, and we're having to do it in different ways and try and approach different groups depending on the urgency and what the particular questions are. So that's still a lack. Very good support from the HSE centrally and management, but we're still lacking some ADM leads, and they've been really helpful in places in trying to get to the nitty-gritty, particularly in dealing with the nursing home support scheme. So it's important that occurs, and just to be conscious, the workload has by and large fallen on social work, and that needs to be reflected in manpower planning for the future. It's not just the usual moaning of staff about shortages. It really has made a big difference to how things work for them, and in fact doing work on ADM matters has delayed other important matters, so we can't keep squeezing social work in that way. We've had to deal with a lot of capacity assessment myths, and I think successfully by and large, where people were obsessed that they would have to identify capacity in lack of capacity wherever it is and do things. And the idea is, no, you don't. Most good practice will continue as it should. It's when there's a good reason to think about capacity and you need to have some idea as to what you're going to do with the result. And again, a reminder for people that this Act is not about empowering healthcare professionals. So you're not collecting a pile of new powers if you identify a lack of capacity. And people don't have to prove anything. You have to prove it if you're going to challenge capacity. The 3 tiers, and it's been a consistent message from the beginning, is they're there to support the person. They're not mandatory interventions. You don't use them unless you need to. And that particularly goes for the final tier, the last tier of the Circuit Court appointing a decision-making representative. And again, we've had to keep batting down expectations. I had my clinic last week, a director of nursing in a nursing home had the bright idea that we could get a DMR to appoint the sensible daughter, so she then wouldn't have to interact with the annoying daughter. So it's hard to know where to start sometimes with these. There hasn't actually been a rush for Part 5 applications by and large. It has been dominated, and I suspect it was always going to be, by the nursing home support scheme, and particularly the ancillary state support, the loan or mortgage, because it is a more complex decision. There have been some unnecessary requests, and we still need to ask people to go back. Presumption of capacity, that even if it is a nursing home support scheme application, a lot of it is quite straightforward. If you think you need a nursing home, we can support you to make your own application. We've dealt with the banking institutions, as Anya said, to try and make sure we can access the necessary information. Even ancillary state support, some people, you sit them down, you go through it, it's not insurmountable for all people. So you go back to basics and think about the presumption and supporting people. We're still trying to work out, I think, how best to use where a DMR is an appropriate consideration for non-financial matters, but that's fine. We'll continue working on that. One I've mentioned, and Anya's mentioned, the co-decision making, and I think a relative neglect still in terms of thinking about it as a viable option. And it is a very novel concept. It's Irish law, it's nowhere else. And where is it in the middle here, where somebody has capacity to make a decision with support or lacks capacity even with maximum support? And I think the concept is it should be as large a space in the middle as possible, that it's there to stretch out the person's autonomy. And it's also under consideration if it's a Part 5 application, as Anya said. Could they potentially have made decisions jointly with somebody if they were lucky enough to have somebody? So it is new, and I think we need to work it out. And I think the training that's just gone up online that Anya has mentioned will be helpful in trying to give people more confidence in identifying where a co-decision-making agreement is an option. The guiding principles, we said to people from the beginning, don't be obsessing about the 3-tier support and about circuit courts and other courts and the DSS. The guiding principles is the spirit of the Act. We have a good awareness. We still have a few tweaks in terms of the language. There's a presumption of capacity, but it is rebuttable. It's not really a right to make unwise decisions. It's just merely making unwise decisions doesn't mean you lack capacity. And I put here the quote from the Codes of Practice, because the guiding principles are for everybody interacting with relevant persons. So it is saying, if you're going to obsess about something, the guiding principles are the place to go. And it's been particularly useful in the idea of consent for treatment, because the myth of next of kin consent is all pervasive in the system and always has been, that somebody can consent on behalf of an adult who lacks capacity. And that's never been the case. But when ADM came in, then we have had, and we continue to have people coming saying, do I need to get a DMR to make healthcare decisions? And no is the answer. Go back to the guiding principles and utilise them and act as if they were interventions under the Act. So the consent policy says, is it for the benefit? And you shouldn't be proposing it if it weren't. Will and preference, past and present, if ascertainable, and consider the views of others who need to be considered. And if all your ducks are in a row, then go ahead and provide the intervention on that basis. And there are exceptions. We have some slow learning. We still get complaints and wondering where the next of kin consent form is meant to be. But I think we're working through it slowly and gradually. We're going to talk about the Part 5 applications and quality of reports later, which is important. We also need to plan for the beginning of the reviews of existing decision-making representatives, and that will probably need some tweaks as to how we do assessments there. The training is up online, which is great news. We've other groups we need to access better, and again, future care planning. If we do things like EPOAs now, then we won't need DMRs in 15, 20 years. So really important that we get that up and running properly. Thank you very much.
Thank you very much, Sean, for speaking under the time as well. I think your colleagues on the panel will be very grateful to you, okay, as well as the audience in terms of increased time maybe for questions and answers. So next up is Joanne Condon. I get the pleasure of introducing my boss. This is the first. So Joanne is National Manager for the National Advocacy Service for People with Disabilities, and she's worked with NAS for the past 10 years. Joanne is a member of the HSE Implementation Oversight Group for the AGM, and also involved in the Deprivation of Liberty Expert Group with the Department of Health, amongst many other roles. And she's going to speak to us about the experience of NAS to date with the Act.
Thanks very much, Susie, and good morning, everybody, and welcome to Cork. This is a very rare occasion for me where, for once, I don't feel out of place with my Cork accent. So I'm going to enjoy that. I have to say, in terms of this task, to reflect on 19 months of the Assisted Decision Making Act, it challenged my own decision making as to what to highlight and concentrate on. There's so much to think about. But I'm going to be very good and I'm going to stick to the brief. So there's 3 key questions that I'm going to cover. What has happened? Where are the gaps? And what needs to change? And of course, needless to say, I'm going to be specifically looking at this through the lens of an independent advocacy service. For anybody here who hasn't heard of the National Advocacy Service for People with Disabilities, we are a nationwide, free, confidential, representative advocacy service for people with disabilities. So just to give you some sense of those that we support, the cohort of breakdown of disability type, you will see that 45% of those we support have an intellectual disability, and you can see the remaining breakdown there. So what has happened? Question number 1. Well, data-wise, since commencement of the Act, 23% of our advocacy work has related to the broad area of assisted decision making. Now, you'll note from these figures that the majority of our work has been in the area of expression of will and preference at 383 of our over 2,327 cases. This chimes very much with the vision of the National Advocacy Service in recognising the capacity of people with disabilities to make their own decisions equally with others, in accordance with the CRPD. NAS is chiefly focused on supporting the core spirit of the Act, namely supporting people with disabilities to exercise their autonomy, participate fully in decision-making that affects their lives. And the majority of our work in this space, encouragingly, has been to encourage people with disabilities to be viewed as equal members of our society with the full spectrum of rights and freedoms as everybody else. Our chief focus has been on empowering people and recognising their right to legal recognition before the law, which Susie spoke about so well last night. The NAS Code of Practice, Standard 2.1, says that independent representative and empowerment advocacy aims to support people to have greater control over their lives and maximise their involvement in decision-making, which relates to their advocacy goals. Of course, we've had touch points with all of the various parts of the Act, as you can see on the screen, and I've also included at the bottom the issues in supporting people around deprivation of liberty issues, which currently sits outside of the Act, but more on that in a little bit. A key question to ask when taking stock of the Act, particularly from an advocacy perspective, is whether people are being more empowered or disempowered overall since commencement of the Act. Are interventions person-centred? Whose needs are being served by the interventions? We need to examine the outcomes coming from interventions under the Act. Are they meeting people's needs? Are they reflecting people's will and preference? Or are interventions more about different services' needs? The intention of the Act is to see more supported decision-making taking place. Is that what we're seeing? Are people being empowered to the greatest extent possible? Or is the Act resulting in further institutionalisation rather than seeing people as people, rights holders, citizens with rights? Well, one quick way to analyse all of these questions is to get back to the guiding principles of the Act. The heart of the Act, as I've called it here. In NAS's experience, there is a sense that the guiding principles are not taking centre stage. We regularly experience an overemphasis on people rushing straight to formal decision-making arrangements, and especially the highest level of formal support. It comes up in most of our inquiry conversations. Yet NAS has countless examples. You can look through our yearly case books where people with disabilities are well supported to successfully navigate decision making, even in relation to the most complex of matters, such as right of residency issues, wills, trusts, inheritance, where and with whom to live, without any need for a formal decision-making arrangement. In our experience, urgency is the enemy of adherence to the guiding principles, and advocates have most certainly found themselves regularly playing the role of proportionality keepers to slow things down, point to more effort being required to ensure that all efforts are genuinely exhausted to support people to make their own decisions. We need a new architecture to scaffold the ADM and translate it into meaningful, high-quality supported decision-making, where people have the chance to learn the skill of decision-making, they have access to accessible, sufficient levels of information to maximise their autonomy. Not just as adults, we need a new system built in to also teach children with disabilities how to make their own decisions. Of course, there's also some good news to report. Niall Burnell mentioned yesterday the excessive overflow of information, and I think the HSE Human Rights and Equality team in particular have done amazing work in building training resources, information, webinars, newsletters, and of course the establishment of the ADM Leads and Mentoring Programme. Our advocates have reported that these have been most useful on many, many occasions to move things along where issues have arisen. The presumption of capacity has been a very useful tool in discussing change and making it materialise. The flexible facilitation of people to engage in court that we heard about last night, and indeed the centrality of the voice of the person in the court process, has been very welcome. We have so many good examples of the court operating in line with the guiding principles and ensuring proportionality. The example last night given of DMRs not being granted where perhaps a co-decision-making agreement was more appropriate. We've seen really positive signs of a move away from a best interest to a will and preference across multiple sectors. And the Code for Independent Advocates has been most useful to us, particularly where challenges have come to the legitimacy of the role of an advocate, or where DMRs believe that they have a right to discharge the duties of an advocate. So, turning to question 2, where are the gaps? Well, the predominant focus needs to be on supported decision-making, as I've already said. Proportionality needs to be centre stage to stop this rush to the most restrictive option. We need to stop thinking that everyone needs a formal decision-making arrangement. They don't. Capacity hunting continues. Sean referenced this idea that people have to have their capacity tested. And I know last night we touched on the issue of banking and finances. We've seen that a lot in our advocacy work, where people are being asked to prove their capacity to open bank accounts and the like. There's a broad misunderstanding of the role of independent advocacy and indeed inadequate resourcing of independent advocacy, which I'm going to come to separately. Advocacy referrals are coming too late in the process. In a broad sense, we often hear that speed kills. I'm going to introduce that concept here in the context of ADM. Speed kills good advocacy. Speed kills good decision-making. And we also have seen rubber stamping, requests for advocates to come and to sign off on will and preference records without any meaningful engagement with the person. That is not meaningful advocacy. We've also seen a lack of due process at times and a breach of procedures for the relevant person, where they're not supported to seek legal aid, or they're unaware of applications that are being made on their behalf. In many cases, the voice of the person is getting lost, and there isn't a meaningful opportunity to hear what it is that they want for their life. The skill of supported decision-making needs attention, especially for people who communicate differently. Capacity assessments. We'd like to ask the question, are they all functional? Training is most certainly required, and I welcome the introduction of the training programme. Are capacity assessments up to date? Our advocates have encountered some capacity assessments that are, old and people have made recoveries, for example, in the case of acquired brain injury that is not being reflected in out-of-date assessments. And the other question we would ask in relation to capacity assessments is, in some instances, are those capacity assessments independent of conflict of interest? So, for example, if a particular service makes an application and the capacity assessment has been conducted in that same place, certainly there have been times where the question of the conflict of interest has arisen. And overall, we are still encountering professionals who have not heard of the Act, which is hard to imagine, but that is our experience. So coming to the role of the independent advocate in court proceedings, we heard last night that if the person is not in court, it is very important that the voice is heard, and we indeed support that approach. Part 50 of the Act gives the court the power to seek reports from healthcare professionals or other relevant experts where that might be useful in making an order or indeed reviewing. So Part 50 of the Act, I was saying, this does raise some contradictions and fundamental principle issues for independent advocacy. Independent advocacy must be structurally independent from other services. It must be person-led and directed. On the screen here, you will see an excerpt from the NAS Code of Practice, Standard 1.1. It says that independent representative and empowerment advocacy is led and guided by the will and preference and rights of people who use the service. We work exclusively for the person, and we are not influenced or compromised in carrying out our independent role by any other party. It points to fundamental considerations around protecting the independent nature of advocacy and maintaining it. Yes, advocacy can play a significant key role in supporting the voice of the person in court, but strictly where it is fully directed by the person only in order to be compliant with our code of practice and with ethical advocacy practice. I don't know what's going on here, but we're missing several slides, so I'll just keep going. Question 3, what needs to change? So the guiding principles, we need to get back to them. We need to get back to, the core clue is in the name of the Act. We need to get back to focusing on assisting and get off capacity. Capacity is in brackets in the name of this legislation for a reason. It's about supporting people to exercise their autonomy and participate in decision-making to the greatest extent possible. Focus should not be predominantly on formal arrangements. We need to employ an empowering approach, not a protective approach. And we need to do more planning ahead, as Sean has already referenced. As the song says, it ain't what you do, it's the way that you do it. How the Act is implemented in remaining aligned to the guiding principles is fundamental to the recognition of personhood that Susie spoke so well about last night. We need to keep in mind this Act is ultimately about recognising that people are people, they're citizens with rights. We risk the illusion of change if we're not careful about how we are implementing the Act. We must not forget the person. The concept of co-decision making in and of itself is an empowering one, but I'm going to give you an example of how wrong it can go when the Act is implemented in the wrong way. We recently became aware of a person whose parent had written out a 15-point co-decision making draft agreement. This agreement included what job the person should work in. An independent social worker was appointed to undertake a capacity assessment. They were provided with a copy of this draft co-decision making arrangement that had been written by the person's parent. The independent social worker then contacted the independent advocate who was already working with the person. The only question that they asked the independent advocate was for guidance on how they should best communicate the contents of the co-decision making plan to the relevant person. The relevant person had no involvement in drafting the contents. Their will and preference was not represented. This is not what the Act envisaged, but for this person, it's what it became. We have to consider that there is ongoing challenges with regard to power imbalances, duress, and indeed even identifying when these are at play. I'm going to turn now to the idea of adequate resourcing for advocacy. Article 12.3 of the CRPD provides that persons with disabilities are to have access to the supports they require to exercise their legal capacity. It's one thing to have legal capacity. It's a whole other thing to be supported to exercise it. And independent advocacy plays a fundamental role in helping people to exercise their rights. Yet it is absolutely inadequately funded in this country. There is no strategy from the government to look at the future of advocacy and the demand which has accelerated significantly over the last few years and will only continue to do so. We would also ask the question, are further resources needed for the Circuit Court, where perhaps a person does not wish to engage with an advocate and the court does require further information as to the person's will and preference? We ask the question, is the court adequately resourced to have boots put on the ground to obtain that information? Wards of court. We see a very slow pace of discharge of wards, and we would really like to see a clear strategy to progress same. We believe more information being provided to people and to committees to dispel fears may be preventing, the fears that may be preventing progress is key. We support all initiatives that are currently underway and would like to see that the people of ward, the number of people who are wards of court being discharged would accelerate. We heard last night there are still 1,918 people yet to be reviewed. Finally, other relevant and law reform that is required that is connected to this. We of course know that there is work underway to develop protection of liberty safeguards legislation, which is currently a gap. The reform of the Mental Health Act, I'm sure you're all aware, but that is grossly overdue to be completely overhauled and does have quite a connection to rights in relation to much of what we've discussed. Reform of the Disability Act, it's outdated, it predates human rights legislation, human rights approaches, and equally a review of legislation underpinning the provision of the National Advocacy Service, the COARLA Act and the Citizens Information Act, which are now respectively 17 and 20 years out of date, again predating human rights legislation. That brings it to a close. I simply want to finish by saying, let's not see this act as something that applies to other people. I want to mention intersectionality as I finish. We wear different hats as human beings. We don't just wear the hat of workers who are supporting other people to make decisions. This is an act that could apply to you or to I tomorrow, next week, next year. It's an act that applies to many of our family members today, tomorrow, next year. And indeed, it's obviously very relevant in the context of much of our work. It's in all of our interest to ensure that the Act stays true to the spirit, the heart of the Act, and to recognise personhood and uphold rights for all of our sakes. Thank you very much.
Thanks very much, Joanne. Next up this morning, we're joined by Roisin O'Neill, who is Quality and Safety Manager with St Michael's House in Dublin. Roisin has well over 20 years experience in social care with children and adults with disabilities, and also has experience working in addiction and also teaching social care. So her most recent experience is in person-centred planning, and she's also involved in the HSC's ADM mentoring programme, where we most recently met at the celebration of the first year of that programme. So Roisin, over to you.
Great, thanks Susie. Good morning everybody. So I just firstly want to say thank you for the opportunity to speak this morning. I suppose it's a really fitting way to celebrate International Day of Disabilities, a real opportunity to pause and reflect on this important piece of legislation. This year's theme is amplifying the leadership of persons with a disability for an sustainable and inclusive and sustainable future. And one of the key messages is that people with disabilities have the right to participate fully and effectively in decisions that affect their lives. So what a better backdrop to today's discussion. Last night, Caoimhe mentioned the event that was last held in Cork in 2019 and the need to start a village of people to raise awareness in terms of the Assisted Decision Making Act. And I'm delighted to say that many of my colleagues were part of the original village people. They began to identify the important possibilities and challenges of assisted decision making for people with disabilities who use services within St Michael's House. We identified the need to work with the willing. Was clear then, and it's still very much clear and evident today. It was evident last night. You could sense it in the room from all of the contributions. A willingness not only for the Act to succeed, but also to champion the rights of people with disability across the sectors of society. I was particularly encouraged to hear the efforts that both Judge O'Connor and Heaslip make to ensure that the voice of the relevant person is heard in court. I was motivated by Susie's words and found myself questioning whether, as a health and social care professional, am I doing enough? But we are the willing. We are willing to act on, and we're motivated by the possibilities for positive change. From those early days, we sought to identify ways to raise awareness about the Act. We recognised the need to be proactive. And that's an approach that's not always afforded to disability services. We're always working in a much more reactive manner. We established a working group. We mapped out several streams of work. The actions identified in those early days are still very relevant today. And it would be an opportunity missed if I didn't mention that those streams, those work streams, are in addition to the very busy roles that willing army already have and hold. We're always time poor. Resources, funding, staffing, retention issues often take the focus away and deflect from the good work that's done every day, often in small ways, often unseen by staff working within the disability sector. So we started to look at the positives, always a good place to start. We identified the possibilities for the people that we support, the possibilities to improve the quality of life of those we support, in terms of having equal recognition before the law, to fully implement the UN CDPR and to allow for greater autonomy, opportunities to make what others may deem unwise decisions. And we also hoped the possibility that the people we support would have full recognition as decision makers. We also recognise that the individuals that we support will be able to lead out and be involved in the implementation of this Act across the service. We also identified that the Act may present some challenges. It may present challenges for the families of the individuals we support. Many consider the Act a major shift. We acknowledge that this is difficult still today. The need to support families who may have English as a first language and also who may have limited understanding of Irish legislation. In terms of risky decisions, the discussion centred around who holds that risk. What if something goes wrong? And I suppose that's always a very prevalent question for any family member supporting somebody to make decisions. For the staff within our services, it is a dilemma of being engaged and supporting unwise decisions, acknowledging the range of abilities of those we support who may have had limited past experience making decisions. The availability of resources, how will we resource this change? And that's still a question we ask ourselves on a regular basis. So to overcome these challenges, we began to set out actions to determine the what, the who, the how, and the when. What are we going to do? Who do we need to involve? How will we do it? And when will we do it? So the work streams range from communication, education and training, enabling content, creating effective interventions, and I'll touch on just a few areas because I'm very conscious of Elaine with her timekeeping skills. So in terms of the communication strand, we identified from the very early days the need to use accessible language in all of our communication to make sure that the information is relevant to people, to make will and preference real for the people we support. What matters to me? To develop clear and appropriate language for all stakeholders. And in disability services, the importance of communication is pitched at so many levels. In this room, we are privileged and we have had the time to immerse ourselves in the language of the Act. Still, for many individuals, staff and families we support, the Act is cumbersome. It's filled with complicated language, some of which doesn't translate or is unheard of within disability services, inherent jurisdiction for one. In fact, a whole new lexicon has opened up, and just when I thought there wasn't an abbreviation I hadn't heard of, in came a whole raft of new ones. This is a privilege that's not afforded to all. Many family members who are busy supporting their adults, children, to consider the wider implications of the Act they aren't afforded that privilege. And more than the understanding of the Act, there seems to be a lack of understanding of the myriad forms of communication, the subtle ways that individuals we support can and do communicate, the powerful ways through behaviour, the quiet ways through body language. It takes time to understand an individual's preferred style of communication, and staff within disability services are very skilled at interpreting this language. Yet once we step outside the safety of services, our skills are often overlooked and undermined. Despite our carefully crafted communication passports, social stories and application of the principles of total communication, the power of the next of kin can often be unleashed. In the early days, there was also talk of an ADM song. I think that's quietly fallen off the agenda, but Joanne, you might have just put it back up there. In terms of enabling content and training and education, we looked to uphold and instill the principles of the Act, to remind all stakeholders that the purpose is to support decision making as a starting point, not to question an individual's capacity. To begin this, we looked at our own language that we use and the terminology applied across the service. We began to shift the question and to question decision making that was not based on the ADM principles, to ask who's making this decision. In terms of best interest, we asked, in whose best interest? We looked at the common ground of the existing support structures within the organisation, identified commonality with the principles of the Act. There are countless examples of how the principles of this Act are already evident in disability services. Examples of ways we can and do document a person's will and preference via person-centred planning, spending time supporting people with disabilities to do the things they enjoy in the places they like with the people they love, doing the things that are important to them, all help to build a picture of an individual's will and preference. Documenting what a person likes and dislikes, how they like to spend their day, to consider how people currently make decisions and to recognise that if there is an informal decision supporter already in that person's life, that doesn't need to change. By recognising that helping to achieve and identify goals for the individuals we support is another way to help build capacity, helps us to focus on what a person can do and move away from a deficit-driven approach that focuses on a person's strength. Staff are constantly finding ways to support individuals to make decisions, to uphold and demonstrate their will and preference, to build on capacity, to focus on what they can do and not what they can't. Every day, those steps are taken to ensure everyone's rights are upheld and that we build upon each individual's capacity, only for that to be undermined by certain sectors of society. Key principles of the Act, such as the presumption of capacity, are still not afforded to people with disabilities. Many examples of poor practice are still evident in interactions across banking sectors. The speed at which some banking officials can determine a person's capacity within seconds of them entering a bank is astounding. Perhaps they could be called on to critique the training. We have learned that navigating the volume of information and misinformation is daunting. The supports required by each person are as unique as each individual that we support. One size does not fit all. Within our organisation, we have forged new alliances as we continue to navigate the Act and find common ground to support understanding across many departments for the many stakeholders. We are learning and continue to learn as individuals we support leave wardship quite slowly and navigate through one or none of the tiers of decision support arrangement. It is without doubt a slow process, and as each individual exits wardship, we are beginning to see the practical applications of the Act in action. Culture change takes time and patience. Some other highlights from the past 5 years within our organisation has been a commitment to ensure that the principles of the Assisted Decision Making Act are incorporated in all policies at time of renewal. A particular focus was placed on updating the money policy to provide increased choice and control relating to personal finance. This review was completed in consultation with the people supported within St Michael's House, who were instrumental in ensuring that the policy focused on individual supports rather than blanket protections. We worked alongside individuals to develop a range of easy read resources. We strengthened our link with colleagues in the National Office and the DSS, hosted online and in-person information sessions for families and staff. We developed a policy on assisted decision making and what it means for St Michael's House. We developed online training as an introduction to assisted decision making for our staff members. We created an AGM resource section within the organisation and a commitment to renew and refresh content on a regular basis. We produced a series of posters, one of which was an infographic to highlight the 9 principles of the assisted decision making. Staff and service users contributed to the HSE e-learning module on AGM, which is used nationally across intellectual disability services and the wider health services. Staff members have been involved in the AGM mentorship programme, where we learnt it's okay to say, I'm not an expert, I don't know the answer to that. The programme has broadened the horizons of staff involved and provided opportunities to engage with other health and social care professionals and to question current practice, and that in itself begins to impact change and affect culture. So the possibilities for AGM is acknowledged across the organisation. It's firmly planted on the agenda. It's embedded in our strategic plan and aligned to our mission statement. And over the last 5 years, our army of the willing has expanded and grown and continues to grow. And we've become more skilled in starting those difficult conversations. So if I was just to end with just 2 asks, they would be that can we please, as a collective group of the willing, focus on supporting the bank sector to do better. Individuals we support are still being denied access to bank accounts, and also to support families of people with disability to understand the possibilities of the Act and to acknowledge their concerns, to support them to understand the possibilities of the Act now. Thank you.
Thanks very much, Roisin. I'd like now to call on Kaylee Toomey, Breed Broderick and Bart Cronin to come and speak with us.
Thank you for this opportunity to speak today. I am non-verbal, but I have a voice. Today my words are spoken by Aisling Kelleher sitting beside me. I have a device that speaks for me, but I don't like to use it because it doesn't show who I am and what I want to say. I have a lot to say. I am a person. I think people should be given an opportunity to speak up. People need to be heard when they do speak up. It needs to be known that people who communicate differently, like me, can make decisions, want to make decisions, and sometimes need support to make decisions. Don't assume because I don't speak that I can't make decisions. I can communicate, it's just a different way of communicating. Talk to me, look at me, make contact with me. Take time and wait. It sometimes takes more time for me to say what I want to say, but it's worth waiting for. We need to slow down. There's too much rushing sometimes. It takes time to think about what someone has said for me to work out an answer so that everyone's on the same page. I need to use the letterboard. It's in front of me here. A lot because I prefer it. That takes work. When I'm using the letterboard, I am making eye contact with the person supporting me. They can see my gestures, what my eyes are telling them, as well as the words and sentences. But you are talking to me, not to the letterboard and not to the person supporting me. We all have the right to make decisions. We are decision makers. We have a voice and our voice must be heard. We speak out and speak up. We should be listened to and our opinions appreciated. Every person has the right to make their own decisions and to have the right support to make their own decisions, to make choices, to be more involved in society. People with intellectual disabilities still don't have enough voice when it comes to making decisions. For example, people with ID want and need more time and sometimes support when there is consultation, discussion and decisions to be made. The right attitudes and ways of communicating are important. Take time. I am a person. I was invited to audit the Orchid Centre in CUH. It is one of the cancer services in CUH to diagnose and treat breast cancer in men and women. I would like to thank them for the invitation. I was listened to by staff. I'd like you to feel what it was like for me in the Orchid Centre. It was an emotional experience being in the Orchid Centre. The things I felt and learned could be useful in other places. I went to audit the Orchid Centre as a person with an ID who uses a wheelchair and is non-verbal. But what affected me the most was that people were sick. My role was to map the patient pathway using my lived experience to audit, make recommendations to improve patient experience. Hospital is a stressful and scary experience, especially when, as I found out, that the time it took for the average patient to check in was very short, and also that the information being shared could be heard by everybody in a busy waiting room. I tried to check in and felt very conscious that I was taking up a lot of time and that it wasn't possible for me to do this alone. The waiting area was not a suitable environment for someone with an ID who could get overstimulated. It was noisy and overwhelming. There was a lot of signs, posters and leaflets around. I didn't know what applied to me as a patient. Also, there were very bright lights, dark purple walls, a TV and a radio on, and a lot of people sitting in rows. I also felt in order for me not to be in the way of a doorway or pathway, I had to rearrange furniture, drawing attention to myself. Support, the right kind, is really important. For example, I went through the mammogram screening process with a staff member. She explained how it works and how she would perform a mammogram on somebody in a wheelchair. Again, there was a lot of information to take in. I asked her could I take time to process the information and make up a list of questions and revisit the screening room later on. When I went back, I came away with a full understanding of how the whole process worked, and it was a lot less confusing. I had time to sort out the questions I needed to ask and get the answers I needed. I went through the mammogram consultation process with a staff member. I felt everything was explained very well to me, and the staff member took great time to make sure I understood what was ahead of me. Myself and the staff member decided that I would make up a mock set of symptoms for my next consultation, at which it would just be me and her communicating with my letterboard. This took longer than my first experience, but I felt it worked a lot better. Overall, the people I met were great. The environment was the problem, and CUH is serious about dealing with that. But people and the environment are important. Before I go, please, for International Day of Disabilities, check out the UCC Rebels manifesto on YouTube ID Plus project. Thank you.
I'd like to thank you for the opportunity to speak today. My name is Brie Broderick and I am a UCC graduate. I did the certificate in Social Citizenship CSC and the certificate in Disability in Inclusive Practice CDIP. I am happy we have the Assisted Decision Making Capacity Act 2015. There needs to be more clarity to make sure that people with intellectual disabilities ID are not discriminated against when making decisions. People with ID still don't have enough voice when it comes to making decisions. People's perceptions about people with ID is that we are not responsible. For example, when it comes to money, when it comes to inheritance, people may leave someone with an ID out of a will because they may feel the person with ID has no understanding of money and think they don't need money as much. There is an ID that people with ID may not have mortgages or families of their own, and that the money wouldn't be needed for them. There is an idea that we have lesser understanding about things like budgeting and money. We get left out of inheritances because families feel it is not needed and we might squander the money foolishly. When it comes to work, people think that everyone with ID should be working in shops. They see people with ID working in shops and they think I have the same needs and desires. I am an individual and I have a right to have my own aspirations and to work towards achieving things the same as everyone else. I need support to make the decisions I want to make and support to be encouraged to succeed in employment. Going to UCC made a vast difference to my life. I was treated as an adult who can make their own decisions. In UCC, we learned with other students in modules like nursing, psychology, education, social policy, and law. It felt like we could achieve because we were learning with other students and having the same experience. Interaction with people who are interested in learning is important. You need the right vibe for learning. In UCC, staff were interested in me as a learner and always made me feel I was well able. Staff always confirmed that I have strengths. One of the big differences is that in UCC, there are learning support staff and peer buddies as well as lecturers. You knew you could go to learning support staff if you needed to, and you'd get support. Peer buddies were friendly faces in co-learning lectures and gave us support with assignments. The paid work placement was really important for me. The staff met with me to help me to decide what area I wanted to work in, to make sure I would be happy and successful. We talked about my strengths and areas I could improve. During the placement, staff checked in with me and my workplace mentor. This is what needs to be done everywhere. There needs to be belief in people with ID from everyone, including employers. People need a chance to show what they can do, but the right support is important. A lot of people with ID are not working. They just don't want to work in shops and clean tables. I believe I can do more, and services need to believe that too. In the services that are supposed to be enabling me to achieve my work aims, I always feel I am being discouraged and often upset after meetings about employment. With the right support and the right employer, I can achieve, and I have proved I can do that. If you don't have something meaningful to do in your life, it affects your health, especially your mental health. It will cost less to support me to achieve my work aims than to treat me for depression because I'm stressed about not being able to succeed in employment. I'm still working in UCC. I've been called back to my placement to do casual hours, but I want to do more. I want a permanent job with prospects, so I don't have to do courses just for the sake of it and to get out of the house. I'm getting older. It gets harder to get a job as you get older. So it's time to get the supports right for me and for people like me to work and to live our lives. It's time to get the law sorted out. Thank you.
Hello, my name is Barth Cronin. Thank you for this opportunity to speak today. I'm here to talk about my experience and what I think is important as we try to make the Assisted Decision Capacity Act 2015 inclusive and work for us all. I think there are changes to be made, and it starts with awareness. Awareness raising is important to me so that people with intellectual disabilities have recognition and respect in our communities. Society needs to wake up to people with disabilities. Government agencies and lawmakers need to collaborate with people with disabilities about awareness. Just stop stereotyping. We deserve dignity and respect. We are here. We are as good as everyone else. We can do it. Recognize us as being capable and contributors to society. Awareness. Wake up to awareness. Talk to us, hear us, and thank you for listening.
Thank you very much to Kaylee, to Breed and to Bart. And Kaylee, in your bio, it says here, I have lots of patience because I have to have lots of patience to live my life. So thank you for your patience, particularly in the audit that you did in the mammogram unit. I had my first mammogram a year ago and it was a very traumatic experience. And I thought after 30 plus years of medical torment that I'd be prepared for anything. So the work you've done is really important in pointing out to services what they need to do to change and making your recommendations. So it's really important. Thank you. So in terms of responding to what we've heard this morning, I'm now calling on Jackie Brown. And Jackie, it says here in the bio that you're retired, and I think that is definitely an error. So Jackie is here today with many roles, one of them being chair of the Disabled Persons Organisation Network. She's also a member of the Disability Advisory Committee for the Irish Human Rights and Equality Commission, which is really important in terms of monitoring and implementation of the Convention. And that committee has a really important role really in advising IREC and monitoring the state. So, Jackie, without further ado, I'll hand over to you to respond to what you've heard this morning and hopefully challenge us in the way ahead, and then we will take questions and answers.
Thank you, Susie. Yeah, I sometimes wonder about being retired too, but in any event, anyway, I am where I am now. Just having heard this session this morning, it would wake anyone up. To me, all I could think of, if I were to sum it up, it was like a really good bottle of wine, but the best was left to last. And that is really important. So I just thought that analogy is whatever, 10 o'clock in the morning might be a nice one. But in any event, so I suppose just to very briefly outline who the DPO network is. So it's the Disabled Persons Organisation Network. We've heard a lot about the voice of the person with a disability, putting people centre and front. We heard yesterday evening, and we've heard it before, how the judges in the Circuit Court and High Court go to such effort to ensure that the voice of the relevant person is in the room, in whatever manner, shape or form that might take, and how they are supported to be in the room. And that is most important when it comes to wardship decisions. So in terms of the DPO network and the members, we're an alliance of 5 national disabled persons organisations in Ireland. We work together with one clear focus, and that is about ensuring the successful implementation of the CRPD, the UN Convention on the Rights of Persons with Disabilities in Ireland, and we want to see that fully implemented. It is a challenge, no more than the ADM Act is. So the 5 member organisations are, as I am, Disabled Women of Ireland, the Independent Living Movement of Ireland, the Irish Deaf Society, the National Platform of Self-Advocates. So they're the 5 member organisations. So between them, we have a great cross-impairment analysis, we have great breadth of experience, and there are many other people in those groups and organisations that, back to intersectionality, have many identities. We have traveller groups involved, people living with mental health experience. So nobody belongs to one nice, neat box. It's a bit like capacity. So we represent the disabled person's lived experience. Our expertise in analysis is led and informed by our active input by disabled people, not by others. The input that we provide is a unique opportunity for analysis of the issues that we face on a day-to-day basis in life. We've heard already many times, last night and again today, and we know as the reality, for too many years, disabled people in Ireland, we have been and still continue to be subject to the judgment and opinion of others. Stop stereotyping people, as was mentioned earlier. We are denied and still being denied agency and autonomy. Many people are still incarcerated in congregated settings, in inappropriate mental health institutions. They have not come to the fore yet. They are very much isolated. There's a tier and a hierarchy in disability like there is in every other walk of life. And we have to be mindful about minding and looking out and ensuring that their voice and their lived experience is brought to the fore, just like everyone else. They have the same rights as we all do. Decisions are, and still are, often still being made for us and about us, and not by us or with us. And that needs to change much more rapidly. And why is all this? It's been referenced a little bit earlier on, and we obviously welcome hugely the Assisted Decision Making Act and the legislation, but we must understand where we're coming from. Ireland, you know, we've heard a lot recently during the election. We are a young country in some ways, and we are still living with the impact of what is referred to the charity model of disability, which is where people who were different, who looked different, behaved different, spoke differently, you know, that they were incarcerated, that they were pushed away, that they were hidden, that we reminded people we were, you know, fed them, watered them and everything else, but they were minded behind high walls. The origins of a lot of the famine and the workhouses, many of them became institutions where disabled people ended up living in huge congregated settings, and we still have nearly 2,000 people to come out of congregated settings. So we're not there by a long shot, yes. So we are now moving more and more towards a rights-based model of disability, and of course the Assisted Decision Making Act is a core part of that. Well, a long way to go as well, but it's great to see the progress that is still being made and the commitment to it from all sectors in society, amongst those who know. We know we're talking to the converted in this room. The problem is we need to treble the size of this room with more people, with more awareness, and with more people to an understanding of the Act and the value of the Act and the potential that it offers everyone. So we just need to just knock back this idea that the charity model, unfortunately, is still alive and well, and we have to move towards human rights model of disability. For a long time, we've spoken about a social model of disability, but we're even moving beyond that. It is now a human rights issue. So the Decision Making Act, as you all know, also very importantly provides for about 2,000 adults who are wards of court to be discharged from the High Court within 3 years of the Act. Now, as we know, the progress and the rate of progress is quite slow. That is no reflection on the existing attempts, but it's due to the lack of resources. So it must be acknowledged, and we do need to resource and speed up this. I don't see it happening, the discharge process happening within 3 years. Hopefully, things will speed up on that. What is of concern, though, still is only recently, again, we read in the Irish Times that some legal sources say that the committees representing wards have to date been slow to discharge orders for reasons including their view, that's the committee's view, that the ward's interests are well protected by the court. That needs to be challenged and that needs to be changed. But it also needs to be challenged and changed by supporting wards of court to understand what the Act is about, why we need to introduce it, and why people need to be afforded their right to be discharged from wardship. So we heard many points highlighted, and I'm not going to reiterate them. Sean, for years I've been listening to him, and I've learned so much from you, Sean, really hammering home that notion of presumption of capacity. Just get that. It's very easy, and there's so many good examples and so many good resources out there. And that is really important to ensuring the autonomy and control for disabled people in Irish life. Unless we start with that premise, we are not going anywhere. And then we can look through to our tiers of support. We heard very eloquently from Kaylee, Breed and Bart about the importance of support. And that support can be in many forms. It's unique and it's different for everyone. I really liked the idea of stop pigeonholing people into a job in the shop, stacking shelves or whatever. But if you're trying to put it around peg in a square hole, that's just not going to work. We have to respect individuality and people's individual choices, opinions and preferences in life. Back to the will and preference. One other significant area of concern that many disabled people have, and certainly it's come up in the GPO network, is the notion of next of kin. It's been referenced before, it was referenced again this morning. It's not been knocked on the head. And most of all, it's not been knocked on the head by some professionals, particularly in the medical world. There are some forms still out there. And I know we're tackling primarily the public health sector. I'm telling you, there's as many of those forms out in the private health sector as well. We need to go out there and need to knock heads and need to provide assistance and direction. We need to be a bit more directive around the idea that next of kin doesn't even legally exist. It's not valid, as we know, but many people don't believe it. Many families still use next of kin and are assumed to be next of kin inappropriately. And that is very risky in terms of coercion, control, abuse, and otherwise. So we need to be very mindful of that. So there's a good bit of work to be done on that. And that's about awareness. That's about supporting people to understand. And families, it's really important. So the experiences of the National Advocacy Service are wonderful. And the service they provide is fantastic. But it's still really concerning to see the number of deprivation of liberty issues coming up. While we know that that's not currently being spoken about today, Ireland has expressed and entered what's known as 2 reservations under the UN CRPD, and there are reservations in Article 12 and Article 14 of the CRPD. So there are reservations on the deprivation of liberty, and we also need to make sure that these are addressed under the reform, particularly of the Mental Health Act, but also the Disability Act of 2005. Some people indeed would reference that the Disability Act of 2005 maybe could even be scrapped at this stage. There are elements of it so out of date, and not only, and I would agree that NAS and the Core Act needs to be reformed. I would about the National Disability Authority. There's been no mention of that here today, but they also need significant reformation as well. So we just need to address some of these things. So the 9 principles of the Act, we talk to them all the time in the GPO network, really important and really helpful. And I think we could send out those 9 principles to so many more people. They're easy to understand, they're in plain English, and they can be delivered very well. And I think some of the examples that Roisin shared of the effort and the time and the resources that you've put into developing awareness in your services, with service users, and you referenced families as well, I think that's to be commended, but we need a lot more of that and a lot more support for it as well. So I'm conscious of my time. So we have made progress, but we have an awful long way to go to break down the years of systemic barriers, both internally, in services, and in the wider community where we all have a right to live. There was reference there about stop stereotyping people. It is time to stop that. Meaningful engagement is critical to the successful implementation of the Act, and especially to the exiting of out of wardship. A meaningful engagement has been spoken about quite a lot yesterday and especially this morning. And that looks different and feels different for different players and different actors. And that's what we mean by ensuring that the voice of the relevant person, as the case may be, is in the room, centre stage. And for any bit of guidance, we spoke about our first consultation, or not consultation, on a position paper on the role of GPO organisations in Ireland. It's published, it's on the gponetwork.ie website. That speaks quite a lot to what meaningful engagement is about, or what it looks like. and how it might be helpful. So it's something, and we did that, and a lot of it was written by the National Platform of Advocates. So it's user-friendly, it's appropriate. We are currently in the process of developing our next position paper, and that is going to be on co-creation. And we have had many conversations and dialogue internally, and what we're talking about, this is where we need to go. About co-creation is about not only meaningful engagement, but it's about working in partnership. It's about developing a future for everyone, where everyone is respected. It's about, sorry to borrow the phrase, parity of esteem. Now, our judgment of parity of esteem and somebody else's might be different, but it's really important. So it's just about the active involvement of all stakeholders as equals, right from the get-go, from exploring ideas to implementing issues and solutions. And not being afraid to make a mistake. Okay, we have to amend that, we have to fix that, we could do it a different way. So we need a clear focus on all stakeholders' experience and expertise around the table. We need much more direct interaction with stakeholders, which includes resourcing them and supporting people, because to achieve parity of esteem, some people might be starting from a much lower base. So, you know, a rising boat lifts, the rising tide lifts all the boats. So the creation of platforms to promote continual dialogue amongst all stakeholders is really important. And my last point, I think I'm on 1 minute, is I have grave concern about the immediate future, and I'm talking politically here. We've just had the election. All the parlance around disability, particularly in the last 3 weeks, when it comes to the disability and the understanding of disability, it's equated with carers and provision of special services. That is not disability rights. It's not human rights. We need to move that dial hugely, and this is really important when it comes to the development of a programme for government, because that's where the reality will hit home, and that's where we have to fight hard to ensure that the voice and the persons with disabilities are put back where they belong in that programme for government. Thank you.
So, Caoimhe, questions?
So the first question is, how does this act apply to older people?
Oh, okay. Well, we've heard a lot about disabilities, but of course the largest group are people with dementia who have difficulties making decisions. And again, we've a long tradition of going down the protectionist route, and indeed the big problem with deprivation of liberty is being a quick option for people done too quickly. So it applies there as well. They certainly have the opportunity now to engage in future planning, which I think is going to be increasingly important, as I said earlier. So that's a group where that will be extremely relevant. But it is getting it into a sector where there are long-established practices throughout the country, and that's in the community sector, it's in acute hospitals, and it's in residential care settings. It's been slow work, Caoimhe, as I think you know, but I think we're gradually improving it. It just faces all the challenges that everybody has been talking about in that sector as everywhere else. Thank you.
And there are other components of today's events that are going to look at future planning, in particular, which, you know, it would be important to reflect on. Do you want to take another question?
Yep. So individuals want to have lower tiers such as co-decision making supports, but do not like the fact that they have to go through a legal process. So how can they use this process without having to formally register this with the DSS?
Joanne?
Joanne,
Or does Anya want to take it?
Anya.
Is there another microphone on that side? Yes. So if you just give it to Anya, please.
A co-decision-making agreement is a thing. It's a legal thing. It's described in an act, and a process is set out in the act. So you can't have a formal registered co-decision-making agreement without following that process, and we're all bound by the act in that regard. But possibly what the question is driving at is, I don't want to impose my interpretation of it, but what could be intended there is I want to have somebody who supports me. I want to have somebody whose role as that supporter is recognised without necessarily having to go through the hoops of making that a registered co-decision making agreement. And people do have their natural network of support, and those have to be respected where the person is still autonomously deciding, their will and preferences being respected. I think we've all been touching on that theme today, that there shouldn't be the need to move to the formalisation of having a DMA or a co-decision maker if you don't need one, and if it's not beyond the wit of those around you to recognise that you have a natural support who are still helping you decide. Does that make sense? But co-decision making agreements are a thing with the statutory framework associated with them.
Okay, are any other questions?
Loads, yeah. Sorry, yeah. And then, so
One more and we go to the floor.
Yes,
Yeah,
yes,
go on.
boss. Yes. Okay. So, how can we improve advocacy and decision-making support for non-speaking individuals with autism or dual diagnosis of autism and intellectual disability? Many cases and resources, such as those focused on nursing homes with the Fair Deal scheme, emphasise verbal communications, leaving non-speaking individuals represented.
I'm going to mention speed kills again, because one of the biggest threats to meaningful advocacy engagement for people who communicate differently, and Kayleigh very well articulated this point herself, is speed, not being given enough time. That's a resource challenge. So again, I go back to the issue around insufficient resourcing of independent advocacy. Advocacy services are overstretched. They have waiting lists. People shouldn't have to wait for support to exercise their legal capacity. As I said already, it's one thing to have rights, but to have agency to exercise those rights, some people will not be able to do that without advocacy support. And in terms of, I touched on it earlier, meaningful support for people who communicate differently, it takes time, it takes skill, it takes awareness of all the methods of ways in which people communicate, and tuning into that, it's individualized. There isn't one homogenous way to do this. It's about spending time with somebody, getting to know them, building trust, which is the foundation of any good advocacy work, and then working at the person's pace and speed to understand what it is that they want. And advocacy plays a critical role in doing that, amongst other supports that people have. But if people can't even get in the door to access an advocate, they're already disadvantaged. Never mind, say, they may then be living in an institutional environment, which Jackie referenced, where rights are ignored, where assumptions are made that they don't communicate. I reference one example which always has stuck in my mind, where one of our advocates went to visit somebody in a nursing home a number of years ago. And the nursing home referred the person because there was an issue, a complaint going on at the time around something that their family member had made. And they were told at the door of the nursing home, this person does not communicate, they don't have capacity, so best of luck with your advocacy, I don't think it's really going to work out. The advocate brought an iPad with them, and within 10 minutes had basically managed to establish a communication method with the person who was clearly able to articulate their will and preference. So that's just one very simple example where for 10 years that person had lived in a nursing home where everyone assumed they couldn't make decisions, they didn't have opinions, they couldn't communicate. And that's why resourcing advocacy is essential.
And in terms of, Roisin, supporting people who communicate differently, you alluded to some of the things that you and your colleagues have been doing to support people to be recognised under the Act. Have you anything else you want to add on that?
I think we need to move away from putting the onus on the responsibility on the individual with a disability to be the one, yet again, to prove that they can communicate in a certain way, rather it's as us as health and social care professionals and our understanding of the various ways that people can communicate, and to recognise that they're all equally valid. Verbal communication is only one small part of how we communicate. My children, for example, know from the moment I step outside of my bedroom what kind of form I'm in, just from the look on my face. And we all have that power in the room, and equally the individuals that we support have that power to communicate. So rather, the onus is on us as health and social care professionals to understand those various levels of communication, rather than saying that somebody can't. Actually, we can't understand that communication, as opposed to the individual can't communicate, because we're all communication.
Thank you. Okay, go to the floor now. Take questions.
I actually have two questions. I think, Joanne, you kind of, I suppose, answered one of the ones I was going to ask. So we work in an acute setting where I suppose the advocacy referral would be sent, and often we're waiting a couple of months before there's a response. And in the acute setting, we need it straight away. So the time, I suppose, that we're waiting for that response, you know, you mentioned that they're not coming in early enough. We're sending them, but they're not being responded to early enough, you know. So that's one thing. I don't know if you'd comment on it. And the other question was for you, Sean. I'd asked this before, but if someone has appointed a power of attorney, but obviously it's not in effect as of yet, is there a role to look at the co-decision making agreement as well, if the appointee wants to do that? Because obviously this is only post indication a person lacks decision making capacity, and really what is the benefit of looking at one or the other? Because I was in work looking at co-decision making saying, is this a faster process? It isn't really. They're both quite lengthy and take time and require the person to have support to do it. So sorry, there are two questions, but and one was more of a point than anything else, but I don't know if you had a comment on either.
I've forgotten the first one, so I'll take the second one.
Sorry.
Which is, yeah, you can think about whatever you want to think about. If it's there and it hasn't been enacted yet and you want to think about co-decision making, if you want to, it's up to you. I just think it's important that we keep the options open for the person, depending on the decision and what they want themselves. So it's not that you created the enduring power that we have to rush to register. I think that often happens too, because it can cover several decisions and somebody may just need assistance with one decision, for example. So I think we try and keep things as fluid as possible, and yes, you can, and all in favour of it whenever possible. Thank you.
And answering question one, yes, currently we have over 270 something people on a waiting list, which we absolutely abhor. It is not where we want to be. That waiting list has been a challenge for a number of years now, and there isn't any clear strategy as to how independent advocacy is going to be adequately resourced. And there needs to be an interdepartmental focus on a strategy linked to programme for government, and looking at, if we're sincere in an Irish context about being compliant with CRPD and recognising in a real meaningful way the upholding of people's rights, then it has to be looked at. It's a fundamental aspect. It is important to say that we don't have waiting lists in every county. They are concentrated in particular areas of, you know, larger geographical spread. But yes, it's not a good place to be, where on the one hand you're trying to actively, you know, support and encourage people to reach out where they need it, and yet those people could be left sitting on a waiting list for long periods of time.
Okay, I have one person here at the front, and I've used somebody here, so we go there and then we'll come to you. Okay.
Thank you. I suppose it's just on the point of the 270 on a waiting list for advocacy. And I'm just wondering how much of a play is involved in people not presuming capacity there? Because if we're presuming that everybody has capacity, then the number of people requiring that should be small. But I think we're not there yet. I think it goes back to the capacity hunting that people referred to earlier on. I think the minute, as healthcare professionals, and particularly in acute settings, we see some form of disability, then we start to question as opposed to start to support. And I just think we need to be looking at the supporting of people's capacity rather than looking for proof of it.
Yeah.
And the other piece is just in terms of the principles and rolling out assisted decision making. You know, the best person to give that support is whoever is looking for the decision to be made, whether that's the anaesthetist or the social worker or the speech and language therapist. If you're the one looking for consent or approval from the person, then you're the one should be upskilling yourself so that you can best get that information from them and support them. So I think we need to, I suppose, start looking for a bit of a cultural change in ourselves. It's not somebody else's job, it's actually all of our jobs. I think that would be really helpful.
Thank you. Okay, we take this question here. Yeah.
Thanks. I just have a question. Again, I agree, like there's a huge, I work in the disability field, and I do feel there's a huge piece around presumption of capacity. And I think, you know, when you're trying to champion the ADMA, we're often faced with that whole piece around capacity. So I think if more work could be done, kind of providing that education piece, and also, as said before, I think a higher up approach too, where our directors of services, our CEOs and stuff are championing that cause. I think that would help the frontline workers a lot more as well. But my question really relates to around when somebody makes an unwise decision and risk, because working in an organization, I think that's a huge barrier as well. When you are championing somebody's right to choose, is what you face in kind of the risk piece, that nobody wants to hold the risk, and a lot of times the decision isn't supported because of the risk that it poses. So, and then again, when you start looking at higher risk, that's when you really start to come into play with more questions around capacity. So I'm just wondering maybe some tools or ideas how you work with a team that's maybe risk adverse. And for a lot of us, I think that's a big issue.
Okay, no, it's a great question. A number of things. The presumption of capacity can be rebutted. But what happens is the reason for questioning it should not be a diagnosis or a label. So it shouldn't be because you've dementia, you've mental health, you've intellectual disability. It needs to be for very concrete reasons and where there's something you would do as a result. You're absolutely right that we get people who are very risk averse. Unwise decision is a bit of a weasel word, though, isn't it? It covers everything from, ooh, slightly unwise, to that's completely mad. Nobody could possibly do that. So it's just trying to tease it out within that. And that risk averse is, I won't accept any risk. It'll always come back to me. And that's organisational in a way. And if we, as an organisation, we're going through the HSE blame game as to who's to blame when that went wrong. I work in older people's services. A ward where nobody falls is a ward where nobody moves, is one of our oldest mantras. It's very easy to prevent all falls by putting everybody in the bed and doing it. We'll never have a choking incident if we stop people eating and drinking. We simply tube feed them all. You know, I know that gets the absurdity of it, but we actually have to define reasonable parameters. And it goes to is the famous Sir James Mumby quote about what's the use to make somebody safer, it just makes them miserable. But the whole judgment there was about reasonable risk assessment and being upfront about it and supporting each other. And that means supporting each other means expecting the support of the HSE corporately, and that there isn't a blame game, that you will accept there will be falls, there will be accidents, things will happen. And it's, you're right, we have to try and define it better, but not let it go down to a single risk-averse unit led by a risk-averse manager, which is disastrous for everybody. So we need to do better. Thank you.
Thank you. And Roisin, do you have anything just one briefly to add at the end? Because I'd say Michael's House and yourself and your experience, you've lots of experience in risk aversion.
Yeah, no, absolutely. And I suppose even the fact that you're asking the question gives great hope, because you're thinking about the implication of it in practice. And I suppose it's a subject it varies, and the definition of it can vary for every individual. What you consider a risk, I might not even consider a risk. So I suppose it's about making sure that everybody involved in supporting individuals in decision making is able to have those open and honest conversations, and to talk about what their fears might be in terms of any decision that's going to be related to risk for the individual. And I suppose it is, in some way, it's the dynamic risk assessments. It's about knowing, can we change this? Nothing is set in stone, as long as we're making sure we're doing everything within our power to support individuals to make decisions with or without an element of risk.
Everybody now wants to come in and answer this question. So, right, bear with me. Very quickly, 30 seconds each.
30 seconds. I would say introduce a human rights framework to the risk process. What are the risks to the person's human rights? Look at the FREIDA principles. You've got to start introducing different concepts to the risk. What's the risk to the person's quality of life, to their dignity, to their autonomy, to all of the other things that need to be considered?
Okay. And Jackie, last word.
Joanne, still laughing. I will start with that, but all I would add is that it still horrifies me. I sit on many committees, unfortunately, and I've been in many services. The risk register that are in a lot of these services or in these agencies are about 10 times longer than the rights framework.
Yeah.
That says a lot, and that needs to change. The balance between, I've seen the most elegant and beautiful, copious Excel spreadsheets, color-coded and risk-coded from 1 to 5 or whatever you fancy today, so that you were just putting too much time and effort into risk registers and not enough time into people.
Great, thank you very much indeed. Can I, on your behalf, thank the panel for both their inputs and taking the questions and answers today. Thank you very much. Thank you.